The first case is Pennie Marie Davis versus Jackson Public Schools. This is a mini oral argument on the application. You each have 15 minutes. Mr. Mullins, that means if you would like to try and reserve some of that, we ask you to take control of that. And if you are ready, you may begin.
I am ready. I would reserve 5 minutes for rebuttal. And good morning to the court. Thank you for having me. May it please the court, I'm Timothy Mullins, appearing on behalf of Jackson Public Schools. The appellant would argue in this case that this is a case in which liability was imposed without causation. The school district did not illegally retaliate against the plaintiff in this case. I'd like to just hit a few bullet points. The school district acted legally in several respects. It's unquestioned. The school complied with a lawfully issued PPO that said the plaintiff and the student can't be in the same workplace. So the school district took the student out of the class, physically told him to stay out of the plaintiff's area of the school district. Having done that, and having met with her request and complied with the PPO, the plaintiff went on to indicate she was not satisfied with that adjustment or compliance and said, I'm afraid of this kid. I've seen him in the hallway. I think he banged on the door of my classroom. She said, I want this student out. She looked me in the eye and said, I want this student expelled. Okay, that's what she wants. The school district is obligated under law and statute to provide a student with free and appropriate public education. A, that's a legal requirement. B, socially, we would hope that the school would meet its function to students, particularly those students who are disadvantaged, be it socially, economically, or the like. So the school district, in having competing legal obligations, A, I must comply with the PPO and separate this student from this teacher. B, I'm legally obligated to provide the student with the free and appropriate education. So the school acts legally and says, okay, I've only got one high school. This is just Jackson Schools. I've got declining enrollment. I've got limited resources. I've got one high school for this kid to go to high school in. And I don't have a reason for, or I don't want to expel him. I want to try to save him or give an opportunity to go forth and be a productive member of society, which is our function. B, I can take the teacher and transfer her to a different art class where she will have all the same conditions and benefits of employment, and which is entirely consistent with the collective bargaining agreement and otherwise, and happens in school districts all the time. There's nothing.
Mr. Mullins, let me interrupt you. It's 15 minutes can go quickly, so let me just see if my colleagues have questions and we can get back to you if not, okay? Yes. Thank you. Justice Zara?
Thanks. It seems to me this really just comes down to the question of whether we apply in a whistleblower case the but-for causation standard or the motivating factor standard. And I guess the question is, are the differences between the motivating factor and but-for causation standards as different as you make them out to be? It seems to me that when the SCOTUS or this court has applied the motivating factor standard, it has incorporated some elements of but-for causation by requiring that the motivating factor make a difference in the contested employment decision. Are we really that far apart? Is there a need for a choice between one or the other, or is there some middle ground here that's clear from our case law, or that can be extracted from our case law?
Well, my understanding and what was argued and presented to the jury in this particular case is that there can be the claimed retaliation need only be one of the reasons. It doesn't even have to be the motivating reason as to why this transfer took place. Whereas the cases, virtually all of the cases, and certainly the current cases, are suggesting unless there's an illegal motivation that is the cause for what occurred here, okay, then without that, then there's no case. So if we have a mixed motive or competing reasons, which the judge instructed the jury was good enough, maybe it's just one of the reasons, and if it was illegal, that would support a verdict against the school district. But indeed, here, as I've tried to point out, there certainly are legal reasons which were the motivating factor for what occurred here. And even if there might have been a side motion that the plaintiff might contend is an illegal or an improper motivation, if the but-for, if why this transfer occurred was in pursuit of legal means, this case is dismissed. It should have been, because of that, it should have been dismissed at the motion for summary disposition, and that's what the jury instruction should have said. It gives you two completely different results.
Can we get to the results you want without overruling or reversing the DeBano-Griffin case?
Well, I think you have to define, whether it's overruling, I don't know that it requires overruling, but adopting the, what the interpretation or definition of causation is. And that's been addressed in so many different cases, and we bring in line what common meaning or plain meaning of the statute is. I don't know that it requires overruling, but clarification.
But much of the inconsistent case law comes from the Civil Rights Act, and this is a whistleblower's case. Does it make sense for us to address this significant question in a whistleblower case as opposed to waiting for the Civil Rights Act case to come along?
I certainly think so, because in all of these cases where retaliation is there should be a consistent interpretation of, be it civil rights or be it whistleblower or be it, the words are the same. The words are the same as to, and the question becomes, how do we interpret those words? So consistency of the law, consistency of interpretation of the words and how they're applied gives you a more consistent, more understandable, more, in my mind, appropriate rendition of justice.
All right, I'll defer to my colleagues for other questions. Thank you very much.
Justice Viviano.
No questions.
Justice Bernstein.
Hey, Counsel, good morning and very happy New Year to you. I just have a few questions, and I kind of want to expand, if I can, on my colleague. And I just want to kind of ask you, when you're looking at the but-for cause, what are you relying on to indicate that's a solitary issue, that's a single related issue?
I'm not saying it's a single issue. In my mind, the question here before us is, what is the motivating factor for the transfer or the decision that's complained of? There could be multiple issues. The question is, what motivated the employer to do what they're doing, and was that retaliatory? Was it illegal? If it wasn't, then the case is dismissed.
Okay. And now, Counsel, I mean, in this situation, I think, the jury basically, as the fact finder, kind of came back with kind of its own determination. I mean, the jury basically came back and found that there was, in fact, retaliation. The jury came back and found, for all intents and purposes, when you kind of look at the track record here, you lost the trial court, you lost at the Court of Appeals, and now you're ultimately here. The jury basically, as the fact finder, found that ultimately you had a teacher that was, assaulted. The jury then found that, this teacher was then sent to teach in a lower school. I mean, this was a veteran teacher that had been there for a while. And these were all things that were determined by the trier of fact to ultimately be the case. And I guess, the question that, I want to pose to you is that, now you're here at the Supreme Court after you've lost twice. And the question I really want to pose to you is, what is it that you're hoping to gain out of this, for this court to act? What is it that you're hoping for us for this court? What message do you want this court to kind of send?
Good question. First off, I'd go backwards and say the Court of Appeals said, in essence, if you read the opinion, they agree with me, but they just don't have the power to issue the decision that they say all the cases would indicate should be issued. B, the jury, I understand the jury issued in response to a very confusing and I would argue incorrect instruction that there might be 20 different reasons as to why this occurred, if any one of them is illegal. It doesn't even have to be what actually motivated these people to do it. Everything they did might have been legal, but the instruction says if you find any one of those different factors that went into the employer's decision to be improper, then you find against the employer. And I'm indicating that indeed we don't want to have that. Let's talk reality in schools, okay? In 2017, we passed a law doing away with Engler's zero tolerance, throw kids out for whatever. And we said, let's try to save these kids that are disadvantaged and the like. Well, the reality of this decision is if I've got a problematic kid and I've got a teacher who's not happy with the kid and we're not really sure what to do, well, that poses a risk under this. Well, somebody might say that if you make an adjustment to try to save the kid and keep them in school, you might end up with liability. So I can look at you and I will tell you, as somebody who's the chief advisor of risk management for hundreds of school districts in the world, that with this case in front of me, and if this is the law, when in doubt, throw the kid out. It's easier, it's cheaper, and the consequences which we see here otherwise are what you're going to end up dealing with. Is that what should be? No, that's not what should be. We should be working on behalf of the kids. We should do what we can to keep the employer safe, which we were doing, and to keep the kid in school. Because once somebody from a disadvantaged social, urban, economic, mental state loses that connection to school, which I've heard over and over again might be the only reasonable, decent connection that kid still has to society, he falls off the chart. So I want to, as best as possible, let the administrators of our school do the best they can to keep kids in school until we have to throw them out. But today, with this result that I'm looking at, I got to say, when in doubt, throw them out.
Okay, I have one last question because I don't want to take up any more time. So I'm just going to ask one question. And I think since you kind of brought up the policy side to this, and I appreciate you doing that because that kind of leads me to ask, this question, as we look at this kind of fact pattern, I think, you'd have to apply it kind of individually. And you have a veteran teacher that, and again, this is what the jury ultimately found. You have a veteran teacher who was, concerned for her safety. And again, this wasn't like a teacher that had just signed on. This is a veteran teacher who clearly had some very strong concerns or strong issues as it pertained to the situation based on what the jury found. And I guess my question is, this teacher hadn't done anything like this prior. She clearly had some really strong concerns about this to the point that, this involved the police. And I guess the question I'm going to ask, and this will be my final question, just because of the policy ramifications that you ultimately brought up, is, your message is ultimately, okay, when in doubt, throw the kid out. But at the same time, you have to think about the teachers and their issues and their concerns. So the question I'm going to pose back to you is, when you have a teacher that has this level of concern, how does the situation that developed in Oxford factor into your argument here today from the policy perspective? And this is my last question, so thank you.
It's exactly the same. It's exactly the same. If you have a student in Oxford who, it might appear, because there's much to be learned yet, but unfortunately, he's been locked up in his room for a year or so. He doesn't have a lot of friends. He's essentially been abandoned at home by his parents. He's got dysfunctional parents. Again, these aren't facts. I don't know. We're learning. I'm the attorney for Oxford schools. I've been living in Oxford for the last month, but this is a child who has problems, okay, and meets with counselors, and what should we do? So do we try to work with this kid? Do we refer him to some resources? Or do we just say, hey, you know what? I called the parents in, the parents don't care. You know what? The better thing to do is to just say, hey, goodbye, get out. You look like a problem, you're gonna cause problems. In hindsight, which is 2020, great. Okay, maybe the best thing in the world would have been to have thrown that kid out. But is that what you want to be? That's my whole point. You know, one in 200 million cases of kids who go into high school counselors with all kinds of problems don't pull a gun out and start shooting at people. And in all of those millions and millions of instances, the school and the counselors have an opportunity to try to save that child from the bad environment that's not his fault that he's in.
Okay. Thank you, counsel.
Certainly.
Counsel, your time is almost up, but I'm going to make sure everybody else who has a question has an opportunity to ask it. Justice Clement?
No questions. Thank you.
Justice Kavanaugh?
I want to get, I think we've gotten a little off track of what the issue is here, which is the causation standard. And I appreciate all the policy concerns, but obviously whistleblower cases and the proper causation standard apply outside of the school context as well, right? So we're looking at the causation issue and whether or not, as Justice Zara suggested, whether there is really a lot of light between what you are contending is but for and the motivating factor that has been expressed rather repeatedly through our case law. And I think your position, if I heard you right, was, well, the problem is it just has to be one of the reasons. But I think you're forgetting or you're leaving off the remaining phrase, which is it has to be one of the reasons which made a difference. So the jury can't just find that, you know, it may have been one of the reasons. It has to make a difference. Why is that not an accurate recitation of but-for causation?
Maybe I don't appreciate your question, but the plaintiff has said and did say that the difference between the one standard and the other standard is a huge departure from what's appropriate in a whistleblower case.
Well, I think you're saying it has to be the reason, right? I mean, that would be that it has to be like to the exclusion of others. And the motivating factor is saying it does have to be one of the reasons which made a difference. And isn't that but for causation, which would be because of protected activity?
Well, what I am arguing for, and what cases like Nassar and Gross and Comstock and Boystock have said, is that if the motivating factor is a legal reason, then the plaintiff's case fails. Understanding there might be other considerations or other factors that are brought forth in consideration.
Okay, thank you.
Justice Welch?
Thank you. Counsel, one question I have is, we know that in torts in Michigan, two causes can in fact result in liability, and then in Michigan we have a comparative fault scheme to sort that out. I'm wondering why, based on our past law in the state, based on obviously the jury instruction at issue here, why should we treat a case like this differently than we treat other torts in our state?
I might not appreciate your question, Your Honor. I'm sorry. When you say treat it differently, I'm saying it should be treated and what the appropriate interpretation of the statute and I think the standard and jury instruction that was given does not comport with the developed case law, and therefore it was inaccurate, and the sought for jury instruction should have been given. So I'm not aware of how we're treating it differently. Tort requires a but-for causation, and I'm arguing, as other cases over and over, federal and even suggested in our state courts, that but-for causation should be the determination applied to this very statute, giving the plain meaning of the words in the statute. So I don't know how I'm treating it differently. I'm just asking for an accurate, plain English interpretation of the statute as it's written.
Okay, yeah, and I guess to just clarify, obviously in Michigan we have more than one cause can potentially contribute to an injury. So, and we have a comparative scheme to weigh that. And I guess my question is, doesn't the mixed motive analysis essentially incorporate that idea?
Well, this is not a tort case.
Right, just
it's statutory, and I'm saying look at the statute, look what the statute says, and I am arguing, as a number of these different cases that I've made reference to, that the appropriate interpretation of the statute and the jury instruction that should go with it is the but-for one, not multiple cause tort analysis, because this is not a tort case.
Okay, thank you.
Thank you, Mr. Mullins. We've used up more than your allotted time. Mr. Granzato, you may proceed.
Thank you. Good morning. Mark Granzato on behalf of the plaintiff appellee. I really find myself in an interesting position, unusual position in this case, because number one, the issue that the court has identified in its March 31st order is an issue of great importance to the jurisprudence of the state. I concede that fact. And number two, I am also of the view that the instruction given in this case is incorrect under Michigan law for very different reasons than Mr. Mullins has talked about. Despite those two statements, this is not a case that should proceed any farther in this court. The fact is, leave should be denied in this case. And it should be denied, I think, for two very, very important reasons. The first is I approach this case from a tort perspective. The United States Supreme Court, in the cases that Mr. Mullins has relied upon, dipped into tort law to come up with a causation concept that was applicable in retaliation and discrimination cases. I come at this case from a tort law perspective. And what Mr. Mullins and the defendants do not quite understand is, from a tort perspective, they got a but-for causation instruction in this case. They got a but-for, unquestionably, a but-for causation. And it's in terms of what Justice Kavanaugh and I think one other of the panel has noted here today, that but-for causation instruction is embedded in the words, make a difference. I've cited to you both Michigan tort cases that talk about making a difference as equating with but-for causation. I've also cited to you the rather revealing federal court decisions which have tried to apply the Gross and Nassar decisions, and all of those cases cited in one of the footnotes to my brief talk about making a difference. It constitutes a but-for causation, but really the place to look to realize that they got a but-for causation is the actual genesis of the Supreme Court's decisions in Gross and Nassar, because the genesis of those decisions rests with the dissenting opinion written by Anthony Kennedy in the Price Waterhouse case. And I've cited to the court exactly, and this began the whole debate in the United States Supreme Court over what was, in fact, but-for or motivating factor. And Justice Kennedy said in his dissent in Price Waterhouse, the phrase because of, that was the causation concept in Title VII that was involved in this case, the phrase because of conveys the idea that the motive in question made a difference to the outcome. In other words, and he said also in his opinion, if a motive is not a but-for cause of event, then by definition, it did not make a difference to the outcome. So we have the actual beginnings of this debate that took place in the United States Supreme Court in Justice Kennedy's dissenting opinion in Price Waterhouse. And he twice identifies the critical issue that has to be conveyed to the trier of fact, which is the prohibited conduct must in fact make a difference. And that's exactly the instruction that the defendants got in this case. And they don't quite realize it. But the bizarre thing about this particular case is the but-for causation instruction the defendants requested was way worse than the but-for causation instruction they actually got. And that's the strange thing about this case.
Mr. Granzato, let me interrupt you because I want to make sure everybody gets to ask their questions. Justice Zara.
Thank you, Mr. Granzato. I understand your argument. Well presented. Are you asking us to deny leave, or do you want an opinion to affirm?
Well, I don't believe that the Court of Appeals got this case right either. Okay, I do not. It's an unpublished opinion, and it should stay that way. The Court of Appeals was incorrect in suggesting that but-for is in fact the appropriate standard under Michigan law. I do not believe that that is in fact correct. Okay, and to go back to a question that you asked Mr. Mullins, if I can comment on this, there are cases where the difference is palpable and the difference makes a difference between these two concepts. This is not one of those cases. And it's not one of those cases precisely because the jury's decision in this case was binary. The jury had two explanations. It's not a question. It's not a situation in which the defendants were conceding that they retaliated, but they argued that we would have done these terrible things to Miss Davis anyway. That's not what they were arguing. What they argued in this case is we didn't retaliate. So the jury had two questions before it. Both of them issues of causation. The jury rejected the defendant's position. So to go back to your original question, there are cases where there is no difference. Okay, there is no difference. This happens to be one such case.
Thank you very much.
You're welcome.
Justice Fabiano.
No questions. Thank you.
Justice Bernstein.
Hey, good morning. Happy New Year. I have no questions, but thank you for coming.
Justice Clement.
No questions. Thank you.
Justice Kavanaugh.
Sorry. I just wanted, before we start questions, you were saying that the instruction that the defendant wants is actually worse.
Yes.
What did you mean? What did you mean by that?
Yes, because the only thing that they said in their proposed instruction was the following, that it was bare bones. When I used the term because of, I mean the plaintiff would not have been retaliated against but for her protected activity. The key thing is the instruction that was given actually supplied the key word that the jury could use in deciding whether it was but for, that is, whether it made a difference. They didn't even convey that in the bare bones instruction that they proposed. All they said is but for. What's a jury supposed to do with an instruction that says but for without any further explication? And what's key to understand here is, and I'm again approaching this from a tort perspective, there are actually two different but for components in a tort case, presumably in this type of case as well. And one is more positive, that is whether it was a necessary condition, but the other one is a negative. And I've cited the Dobbs treatise on tort law to try to convey this point. It's a negative, and that is you have to show in tort law that the results would have been different for the plaintiff. Okay, that's what you have to show. And conceptually, as I think it's pretty clear, it's a little more difficult for a jury to understand this negative component of the but-for causation, at least in my opinion. And the defendant's proposed instruction did nothing to assist the jury in deciding what is, in fact, a more difficult concept to apply in a case like this.
Okay, thank you.
Justice Welch.
I have no question.
Mr. Gonzalez, what do we do if we agree with you generally? What do we do with our decision in Hecht? Hecht has this statement that our case law applies a but-for causation standard, which, yes. And then the citations don't support it, but somehow yes. It got through all of our legs, not all of our legs. I think there are a number of justices on here who are excused from that. But
as I think I pointed out in my brief, this court has actually applied, taking into account both the discrimination and retaliation cases, which I would lump in the same group, 3 different standards. Okay, you have the Hecht but-for, Justice Young wrote it, but Justice Young also wrote Hazel, and Hazel talks about motivating factor. And the Snizinski case, a little earlier case, actually applied what I consider to be the Price Waterhouse burden shifting, the plurality decision in Price Waterhouse. So actually in Michigan law, I think you have 3 to pick from. Okay, I would hazard, my opinion is that I don't think any one of them is actually accurate for the application here. You have a motivating factor test. There is a motivating factor test. I think it applies even in Justice Kennedy's version of Title VII or ADAA. But what he has added to that, what the court has added to that in Gross and Nassar, is this idea that the plaintiff must also show that the results would have been different for the plaintiff in the absence of the prohibited conduct. What's really, this is not the appropriate case to take up this issue, I think, because no matter what this court does in this case, the results are going to be the same. Even if you adopted a pure motivating factor test, or even if you adopted the defendant's position of but for, the defendant still loses because they're arguing a jury instruction that was in fact a but for instruction. This is not the appropriate case. The appropriate case, in my estimation, is a case in which a plaintiff challenges this instruction, because this is a but for causation instruction. It is not appropriate in certain cases, okay? And that's my position. And what I coming from a tort perspective in this, that there is one area where but for causation has been found wanting in the tort area. And it really puzzles me that it seems to me that the United States Supreme Court in Nassar and Gross has actually taken the one area where but for causation falls down, and they've tried to apply it to employment cases. Because the one place where but for causation does not apply is where what the restatement refers to as multiple sufficient cause cases. That is a case in which there are multiple causes, each sufficient to result in the bad results, if you will, for the plaintiff. What the courts have recognized, and the classic example, since I have a few seconds, I can tell you, the classic example is obviously two people who each independently make a fire. They make a fire, the fire is joined together, the fires are joined together, and they burn down somebody's house, okay? That is a classic case where but for causation it can't apply. And the reason it can't apply is for the same reason the Supreme Court in Gross and Nassar seems to be adopting it. And that is, if you apply but for causation and the whole concept of making a difference, the one defendant can say, well, it would have happened anyway, because this other person's fire caused the building to be burned down. And the other defendant can make exactly the same argument. So if you look interested, I think it's section 27 of the restatement third talks about this concept. It's the one place where but for causation doesn't work in tort law and must be altered. And the alteration obviously is that both of the fire setters are held liable, despite the fact that each is not the but for cause, okay? But it seems to me that what the Supreme Court has done in these two cases is they've actually taken the but for causation concept where it doesn't apply and put it into these employment cases. And this is something, when the appropriate case comes to this court, is something that this court needs to be looked at. I think it also needs to be looked at. Another wrinkle in this case that I think is very, very important that wasn't discussed in Gross and Nassar is the fact that there are a substantial amount of non-economic damages in this case. I mean, it's one thing to say we would have fired her anyway, okay, and take away damages associated with this had been a termination case. It's one thing to say that we had a separate reason for firing her. But what the defendants are suggesting is plaintiff proves that there was a motivating factor associated with something that's prohibited by Michigan law, that is retaliating for protected conduct under the whistleblowers. There was that, but the defendant can show that we would have taken these actions, these adverse actions against her anyway. Okay, you would have taken those adverse actions. Does that somehow eliminate the non-economic sting of the fact that they did in fact violate this act? I don't know. It's another complicating factor. It's not discussed in Gross and Nassar, but the fact is, this is not the appropriate case for this court to be dealing with what I consider to be a very, very significant issue of Michigan law.
Thank you, Mr. Gonzato. You have 34 seconds. Do you have anything else you want us to know?
I think I'm about done.
Okay. Thank you both. The case will be submitted. I think Mr. Gonzato will see you in an hour or so. So